Welcome to Guardians of Innovation, Patent and Trademark Law.
Welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I'm your host, Sophia Morales, and in today's episode, we're diving into the Ivory Tower IP, how academic innovation meets law. Welcome back, Vincent. I'm looking forward to our conversation today.
Hey, Sophia, how you been?
Fabulous. So fill us in. How does IP law uniquely apply in academic and research environments as compared to the private sector?
Well, you got to understand that everything's with the universities and those type of organizations is owned by the university under the contractual basic contract between the employee and the employer. And that's kind of if you work for a camera company like Sony or Kodak or something, and you invent the new camera, your name is going to go on the patent, but you're going to have to assign all the rights over to the company. So in the very beginning of your employment, you sign all these documents. And again, nobody reads all this stuff. And usually I ask, a professor or, a scientist from the school to give me an idea of why they think this is their intellectual property versus the universities. And I say, look, you have to go into your personnel files, see what you signed, see what it says in that actual contract. And then inside those contracts, they might incorporate by reference a manual, like the school manual. And the school manual or the company manual might talk about what intellectual property is yours and which is not. And a lot of times it centers around when and where you came up with the idea. Like if you're using their laboratories on their time and you're working for it and they basically hired you to do that, they own it. Now, if you're at home and you come up with an idea for a new clock and and what you do for the university is totally not even close to it, then chances are you own your own intellectual property on that. But it's possible that anything you invent while you're working for them is covered under that contract. So it's the underlying contract that you sign with that university. I'm sure every university has, very similar type of contracts, but no two contracts are alike. And everybody says to me, oh, it's just a template, let's put together a template. But everybody's circumstances are different, and you have to either negotiate that prior to signing it. And a lot of times what'll happen is there'll be actual exhibits to the contract of what I invented or what I'm working on now before you even hired me that will stay mine. And then anything after the time that I sign this that I create is going to be the universities. But yeah, like I said, it's pretty much contract driven.
Yeah, and you really do have to pay attention to the details. My husband's had a few contracts come through that we've reviewed, and some of them are pretty broad reaching to the extent of we're paying you salary and you really don't have personal time. So anything you create is ours. I mean, some of them are that far reaching. So it doesn't matter if you've created a novel fiction work, they want credit for it.
Absolutely.
So yeah, it's super important to read those contracts before you sign them.
Absolutely. And the other thing too is when you invent something that's new, and you give it to the university, you let them know, and then there are clauses in these contracts that say, if the university doesn't want to promote it or market it or use it, then you have the option to go out on your own. So, like I said, it's contract driven. No two contracts are the same. You have to evaluate what your contract is, and there are openings like that for inventors to go forward. And sometimes, you just even there's a process to clear certain ideas to say, look, and I would like, I said in the last podcast, it's easier to pull the bandage off up front and get these details ironed out than hope to work on it later when there's a big courtroom fight. So if you can make that addendum to the contract or cross off a couple words or add a new clause, the time to do it is when you sign. That first day before you sign that contract is when you have the most power. Once you sign it, they own you.
Yeah, your leverage is completely gone.
Absolutely.
So I'm going to ask this question just so it's crystal clear for everybody. So when a university researcher invents something groundbreaking, who typically owns the IP?
the university. There is something called shop rights too. Like, like I said, if you invent the new clock and they're hiring you to come up with a new DNA, analysis, and you do it, on your own, there could be the argument that it's yours, right? But if you create something on campus or in their laboratory, then they're going to
Or
say that,
using
yeah.
their laptop.
Yeah, exactly. That you did it, then they're gonna say it's theirs. And like I said, I would want to resolve these issues up front, especially when you're coming in to a new job. If you have these ideas on the back burner that you haven't gotten out around to and you plan on getting to while you're working for them, this might be something that you want to include in the contract that says, look, I'm coming to the table with this. It's already my invention. It's not what you're hiring me to do. It's clearly, established that it was mine, and we'll actually document this in our contract and saying, look, this is mine and this is yours. But again, I think the problem with universities too is that they're really good at doing the research, but there's always three things to do. You have to do research and development, which is basically manufacture. You have to distribute and market. So they might be good on one end of it, but as far as distribute and market a product, that's not what they're in the business for. So a lot of times these ideas, as great as they are, never actually make it to the marketplace.
This is the truth. So, how can a researcher navigate things like publishing their findings without jeopardizing patent rights? Because there's a certain amount of secrecy is required, it seems like, to be protected until that patent's filed.
Absolutely. So yeah, I mean, things like Kickstarter, where you want to try to get funds to do the research and development to get it up, but you have to talk about it. So this is the rule. The rule is that if you make it public in any way, you publish it in a magazine or on the website or in your thesis, you use it in public or you offer it for sale, you have 1 year to file your patent application. Now, there's also another issue that you have to be the first to file it. So if you're riding your new moped down the street and somebody sees you doing it, and it's still within your first year to file it, but they file it first and they say that they're the inventor of it, or even if they invent it on their own independently of ever seeing you, you lose the race to the patent office. So the American Invents Act basically changed the rule from first to invent to first inventor to file. So it's a
Oh,
race to file it. So there is what's known as a provisional patent application, and it's a common misunderstanding. People say, I want to get a provisional patent. Well, there's no such thing as a provisional patent. It's a provisional patent application, and it just puts in stone, it locks in stone your filing date. So I file my provisional patent application today, and I can publish it, use it, offer it for sale, and nobody's going to beat me to the patent office. The
yeah,
thing
because you've already got the date stamp.
Exactly. But now there's another 1 year rule. There's all these rules all the time, and they sometimes get confusing because they sound alike. You have 1 year to file it from the time you use it in public. Well, you have 1 year to file your non-provisional from the date that you file your provisional. And I always say, don't call me on the 364th day and file this tomorrow. So you really got to
Yeah.
make up your mind about 10 months from now that, yeah, this is going in the right direction. People are interested in this, is something I can make money off of, and I better get my non-provisional filed. I've had people call me a week or two later, I got a deal, we got to file this right now. And I get people calling me 10 months later saying, yeah, I haven't really done anything with it, but I don't want to give it up. So let's just file the non-provisional. It's like throwing good money after bad because they're most likely never going to make any money off of it. Nobody ever comes to me and says, I have this terrible idea. No one's going to like it. Everyone's in love with their idea. And they
Of
think it's
course.
going to make millions and millions of dollars, but yet they don't know how to do those three things that we just talked about, manufacturing, marketing, distribution. And we have to wear all these different hats as the inventor, as the independent inventor. And even like we said, the university doesn't even know how to do those type of things, and because there's so many different, classifications and types of inventions, and maybe they're good at one, but not all. And,
Yeah.
maybe you're a marketer, maybe you work in a factory, you're good at manufacturing. Maybe, you have an in with a distribution channel to put it in the store, but you still have to wear all three of those hats, it's difficult. It's never easy. And I always say, when you see somebody, and I have clients making $2 million a month on their products, and everyone says, "Look how easy he has it." And I say, "No, it was hard work and elbow grease." But somebody more might have worked just as hard as him, but just didn't work as efficiently as him. And some people and some entities just touch stuff and it turns to gold, and they know how to create those things. So it's always a combination of everything, and it's a combination of luck and all kinds of things that have to
Yeah.
go in a certain way for you to get from out of your head into the shelf on Walmart.
Exactly. I know with our personal experience over here with it that who's on your team makes a big difference, because if you don't have all three of those areas covered, it's not going to go to market.
Yeah, and I say you have to be like a independent contractor building a house. You got to get three bids from the plumber, the electrician, and the roofer. And if you hire the wrong guy to dig your foundation and the whole house falls down, what good is it that he gave you the best price? So,
Right.
you got to get and I'm just the plumber, I'm just one part of the whole equation as far as protecting the intellectual property, but you have to network and you have to, make these type of connections, and hopefully you make the right ones. And you never know how it goes from person to person to person, and they say, "Oh, I know somebody that can do that for you." And if you don't make those phone calls and you're not on the phone, if you're not networking, you're not doing these type of things, it's not going to work. You really have to work it every single day.
Exactly. And you need the A players, not the cheapest bid.
Yeah.
So
But the
on
cheapest
the,
bit might work. I mean,
you
you
never
just have to
know.
make sure they know it. And that's why I say you have to be street smart and book smart. So book smart is to know, the amount of money it should cost, the type of material that will hold up under stress, the mechanics of it, the distribution channels, the demographics. Those aren't innately understood. Those are things you have to learn. And then the street smart is making sure you don't pick that, the crook that's going to steal your money and not do anything from you. You have this gut feeling where you just know this person's not the right person to work with. And if you usually, if you have questions in your minds and the red flags, usually your initial gut feeling is right and you should go with it.
Yeah, exactly. So, where do technology transfer offices come into this whole ecosystem? And what role do they play in like commercializing university developed IP?
Yeah, I mean, these type of, companies, they're out there, and it's very difficult to get them, for independent people to just get your foot in the door. And a lot of times it's just getting your foot in the door with them and being able to find that right product. I mean, it's just so difficult. There's so many different, organizations like product development companies and people that say they can do these certain things that they eventually really don't do those things for you. And big venture capitalists or angel investors, sometimes they're very, very picky. I call them cherry pickers, right?
Sure.
They're just, if it almost has to be the perfect deal for them to buy it. I sit in a lot of these meetings for these venture capitalists, and there's local meetings here at the Buffalo Club where the Western New York angel investors and a bunch of other groups, they'll listen to presentations, and I'll go and I'll listen to the presentations, and I'm like, wow, this is such a great idea. And it's like one after another with all these great ideas, and then they never seem to pick them up. I'm like, what are they, what am I missing? They just want it to be that perfect deal. So I think a lot of it has to do with just being resilient and over going through the networking and learning the best fit for you.
Yeah. So, what are some of the common legal mistakes that researchers and universities make when it comes to protecting their innovations?
Well, I think the first thing is they don't understand that it's actual patentable subject matter, even like corporate, research and development teams, because they're so into it and they don't see it as this earth-shaking lightning bolt, flash of genius. They just look at it as just, as something that somebody should understand, and it doesn't seem like it's patentable, but they don't realize it is. So I think they have to understand basic three things to, there's, I mean, you teach a whole course on it. I literally teach a course on it, wrote a book on engineers and understanding patent law. But the basics, right down to the nitty gritty, it has to be new. No one's ever done it. And I always say everything's brand new, right? Even if I told everybody in the world to make me a table, top, a bottom, and four legs, we looked at everybody's table next Tuesday, and we would see that they're all different shapes, sizes, colors, made out of different materials. No two are exactly the same, but they're all just still a table. None of them are patentable, right? But they'd all be new, because nobody ever made it exactly that way. So new is the first step. The second one is that it's useful, that it actually works as a table. It does what it's supposed to do. And nobody's ever come to me and said, I have this thing that doesn't do anything. So let's give you a useful. We know it's going to be useful and new. It always comes down to the third one. It's got to be a non-obvious improvement over what's already out there. So when we do our search to see if it's new, useful, and not obvious, we usually have to, what I call, Frankenstein them together. So we get two patents where they have the different parts, and that's what the patent office is going to do, saying if somebody saw this table, it would have been obvious to make your table. If they saw this other piece of art, they call it, prior art, and they basically Frankenstein it together. And then we have to make the argument that, look, even if you put those two things together, those three things together, it still wouldn't make ours because it's missing this important structural piece. And usually that structural piece has some sort of criticality, and that's another word of art. And the criticality is, look, I didn't just change the legs of the table by 2 inches and made it different. I changed the curvature of the table. Now it can hold 5,000 more pounds than the other table. So that piece it's a critical change that allowed it to do this, and nothing else, even put together would do this because it doesn't have this curved leg of this angle or whatever that critical piece is. So that's how you get the patent.
All right. So how can universities and researchers ensure proper IP protection when they collaborate, say, with a private company or government agency, for example?
Well, again, it all comes down to the contract when you first start, and that you understand what is patentable subject matter. The university itself should have disclosure documents that, or the corporation, disclosure documents that their research and development team, marketing team, somebody that comes up with new ideas, that they log it in. So even if that person leaves the university, it's shown, it's provable that it was invented while they were working there. So and then there's got to be some sort of, I don't know, patent policy or committee that looks at it, a patent lawyer, and says, look, I think this is possible to get a patent. Maybe we should do a search on it and make that determination. And then, of course, it always comes down to ROI, right? What's the return on our investment? It's what's it going to cost us to do the search, to file the patent, to get it up to speed, to manufacture it. How much can we sell it for? Are there distribution channels ready to take it? Are they willing to take it? If all those things add up, let's do it. If they don't, we'll hold off on doing it. But that's one way to protect ideas. Another thing that big corporations do to protect their ideas so they don't get sued by somebody else getting the patent is do what's called defensive publication. So a defensive publication puts it out there in public that they invented it. And I actually got hired by a big company to go through some of their defensive publications to sanitize it so nobody could tell it was from IBM or Sony or whatever company it was from, so that people searching for it wouldn't find it and say, oh, this is IBM's property, where it's just kind of floating out there on the internet. And then if it ever has to be proven that it was already out there, and if after it's out there for a full year, that nobody can ever get a patent on it. So they might have thousands of patents that they want to file, but they just can't do them all. So there's
Right.
different ways to protect it so it doesn't come back and haunt you.
Interesting. Yeah, I know my husband uses a lot of material transfer agreements. He's in the drug development space. And so that kind of lays out a lot of what you were talking about around this material, who owns it, what you can know about it, that sort of thing. And
Well,
who
yeah,
owns what
so
we discover when we do the experiments.
Exactly. It's what they discover, and whether or not it's new, useful, and not obvious at the same thing. People say, I put these three things together and it works great. Well, it was expected to work that way. You put in more oil, so it's going to lube it more.
Yeah.
If you put in mustard in your Cheerios, what would you expect? It'll taste like mustardy Cheerios, even though nobody's ever put mustard in their Cheerios, unless it does some sort of unexpected result and it grows hair on the bottom of your tongue or something, or it tastes like strawberries. But if it just tastes like mustardy Cheerios, then you really, even though it's nobody's ever done it before, you're not going to get the patent for that.
Yeah, it's pretty obvious.
Yeah.
So, what final words of advice would you give an early career researcher or a grad student who's interested in protecting their innovations from the get-go?
Well, I think it starts with the contract when you first sign up and work for the company. You have to understand that the company or the university, they're gonna, while you're working and doing that, they're gonna own you, right? And if there's a way to protect it in the beginning, and like I said, I've seen it in the past where if you're already working on some sort of innovation going in, there's a way to document that right from the beginning, so there's no question that you own it, and you get them to agree and sign off it from the beginning.
Yeah, I know with my husband, we specifically put in there that it's a very defined area of work that he's providing for them in
Exactly.
order to allow him to continue to consult with other companies.
Exactly. And
Yeah,
and they have to be able to sign it. And at the end of the day, sometimes they're just not going to agree with you. I remember when I first started working as an attorney, I did some house closings and we'd sit there with the bank. And of course, the bank would have a stack of papers 10 miles high, and we'd have to sign it all if you want to get the mortgage. And the client would say, "Should I sign it?" And I would say, "Look, every one of these papers you have to sign. Because if you don't sign it, they're not going to give you the money. I can
right.
explain to you and you can understand what your rights are with each one of these, but there's not a lot of room, wiggle room to negotiate here. It's either you want the money, you sign the papers. And if you want the job, if you're a young, student coming out of school and you have all these student loans and bills to pay, you need that job. If you're a tenured professor that is in has different leverage, and look, I'm just not going to give you this if you don't do it, and they really want you or this thing, then they're going to be more open to the leverage. But I always say, look, once you sign the document, all your, everything's out the window as far as your
Yeah.
leverage and your ability to negotiate. So I think this is one time where you just don't click the box at the bottom and say, I read everything. You actually do read everything.
Yeah, and maybe you ask for what you want and see if they say no.
You could always ask, right? You
Yeah,
could always
exactly.
ask, and a lot of times they do. I remember one client saying that they were offered $1,700 to post something, and they thought to themselves, if they'll pay 17, I bet you they'll pay 2,500. So they came back with an offer of 4,300. I'll do it for 4,300, thinking that they'll middle it someplace.
Yeah.
And they just came back and said, yes, okay, and they signed it, and they gave me 43. Yeah.
Ding, ding, ding. Points
Yeah.
for
So
asking.
yeah, well, that, and then all of a sudden it's a license to steal. The next person that comes to them, I'm just going to ask for more money and see what happens. And
Yeah, exactly.
they were working with these big fashion industry people, like big, doing posting videos for them for
Yeah.
fashion industries. And once they have a big following, these corporate people come to them and say,
Yeah,
"Look,
and the leverage goes way up.
yeah." And the leverage starts
Yeah,
going higher and higher. Yeah.
beautiful. Thank you for all those insights today, Vincent. It's been a pleasure talking with you as usual.
Hey, thank you, Sophia. I enjoy working with you.
Thank you for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. Visit lotempiolaw.com to hook up with Vincent and the team, and be sure to like, subscribe, and share.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.